Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder at Retzel & Andrus and leader of the healthcare practice. Today, I'm joined by Karen Adinolfi, who's part of our employment services group, and she's been one of my favorite guests to have on.
Thank you.
So welcome. We're going to really be talking about a super hot topic today, and this has to do with the events of October 7th, when the war between Israel and Gaza started, or Hamas, I should say. And there's been a lot of emotion surrounding this topic. And in particular, we've seen a lot of healthcare providers, healthcare workers sharing opinions, engaging in certain acts, posting on social media, and doing certain things related to their opinions on this topic. Maybe they're anti-Palestinian, maybe they're pro-Hamas, they're anti-Semitic. And so one of the things we want to talk about today is, as a healthcare employer, how should you be handling these events? What rights do you have in terms of being able to terminate or not terminate? What obligations do you have to your patients, to your other staff within your practice? And looking at this from a purely employment perspective, because one of the things that's happening is I'm getting some calls, this is coming from our practices, where they're describing to us certain events that are occurring within the practice, comments that are being made, some of the activities of their staff, and they're not sure. So I thought it would be a great topic where we could really talk about how to handle this from an employment perspective, because just like any other employment situation, the rules haven't changed. You have your employment policies, you have your employment contract, and we have the general laws of the state and the country that govern these type of topics. So we still need to look to those things for our answers to make sure that we're handling things appropriately. So that's what we're going to be talking about today, a little bit of a mouthful. But what I want to do is start by asking you, Karen, you see what's going on out there. You see people are posting things on social media. It could be their personal account. It could be an account on Twitter where they're identifying maybe where they work. And I guess the question is, what kinds of things can be posted? What kind of things can't be posted? At what point do we start getting into kind of an employment situation, even though, it's not always 100% clear?
Yeah. Well, the first thing I want to say, just to sort of address, I think what sometimes is the elephant in the room, is that the First Amendment does not apply to private employers. So if you are a purely private employer, healthcare practice, whatnot, if someone says you're violating my First Amendment rights, that's just not an issue. But like Erica said, what you have is your policies, your procedures, and then the general laws of the state that you operate in, as well as the of the United States. So saying that, certainly our employees are allowed to post on social media. They're allowed to have lives outside of the office. And I don't think anyone would really dispute that. But an employer does have an interest in making sure that, even if it's sort of off-duty behavior, that it doesn't come back into the workplace, whether through, the effect on your other employees, effect on your patients, effect on the reputation of your practice, the feeling that perhaps this particular employee or physician wouldn't be giving the right standard of care to someone that they, were posting about or posting against. And so the employer really does have that right and somewhat that responsibility to make sure that what is being posted publicly that can be tied to your practice is appropriate, is not bringing a misguided light onto your practice, and is assuring your patients, the public, your workplace that this is a practice that takes its obligations seriously, that it employs highly skilled doctors and other professionals, and that someone's political views aren't going to taint that impression.
Right. So if somebody's out there, and let's just say they're posting something very anti-Semitic, Hitler didn't get the job done, the more Jews killed, the better. Who cares about how many Palestinians die? They all deserve to die. making this up completely, but just giving you examples of some of the things that actually have been posted. An employer hears about it and their first thought is, oh my God, well, what am I going to do? And this may be a great employee. It could be a doctor, it could be a dentist. So what is the first thing they should be doing when they see that this has been posted? And usually it'll be that they're probably getting bombarded on social media, getting tagged and whatever. What should they do first?
Well, first they want to, take a good look at what's actually been posted. It could be that it's just not clear. Maybe it could have been worded more artfully. But if, as you say, it's something that's, we would find to be reprehensible, unacceptable, I would address it with the employee first and urge them to remove it. They obviously don't have to. It's, nothing you can force them to do. But that to me would be your first step, explaining what the ramifications are. It could be they just didn't realize, they didn't think you'd ever find out about it, that kind of thing. They may be very willing to do that. If not, consult your policies. You probably have some sort of, communications policy, usage policy, even a social media policy, as well as your policies such as harassment and EEO. And you look at those, would this cover that behavior? And typically, I would hope that they'd be broad enough that they could, that, you have someone out in the public making these comments that could, very well cause somebody, whether a patient or a fellow employee, to feel as if they're being targeted or that they could not expect fair or equitable treatment from this person. And if your policies, could conceivably cover that, I think you could look at discipline of that employee. Obviously, if they have a contract of employment, that adds another layer to this, that you would have to look at, permissible ways to discipline under that contract. But if the contract says they must follow all rules and procedures of your practice, or has some other, definition of, what just cause is or whatnot, again, if you can do it, even if you might think, oh, this might not stick down the line, sometimes it's better at least to let someone else say, you know what, that was okay for them to do. You might want to take the stand right now and say, you know what, we're not going to tolerate this. Here's your discipline, whatever it is. Is it termination? Is it suspension? Is it last chance agreement? Whatever it is, again, you've taken the stand and say, we are not going to tolerate this behavior, and to assure our patients and our fellow employees that this is a place where you can expect to be treated fairly and without this kind of hostility.
Right. And many contracts, especially for doctors, for example, working for hospitals and larger practices, will definitely have a reputation provision in their checks that allow for termination. I believe that's probably the one that most of them are using right now to immediately terminate. And I think even for those that don't, they're just terminating and they'll say, we'll figure it out later. You're bringing
let somebody else bring them back or whatever the remedy is, because we're not, we're going to take a stand, and if our contracts don't cover this, well, they should. And, we'll let somebody else figure that out. It could be the reputational clause. It could be just the general clause of you must follow our policies, or, conduct that's however it's phrased, conduct of becoming, conduct that casts doubt on your ability to perform your duties, whatever it is. And, invoke those things, because like you said, when you're out there, even if you don't specifically reference your employer, people will know, your patients will know. They're going to know who it is. And to think that's never going to come back to the employer, I think is a fantasy.
And this is, my goodness, that social media machine out there, they're tracking down every single person. So I don't think anybody's safe thinking nobody's going to know or your employer is not going to find out. It's amazing.
Although I do find that the younger generation really still, even after all these years, has a sense that whatever I put out there, it's mine. That I can say whatever I want, and either no one's going to find out or they can't say anything about it. And that's just not true.
And along those lines, some of the most egregious postings that have been reported are coming from medical students and residents and fellows. So if, think about your future career and reputation. If this is something that gets back, let's say you don't get terminated from your program and you get away with it, it's still out there.
And the internet's forever, like they say. And Screenshots will survive you taking down your post. I would never assume that it would just go away. And I think that's, the lesson we tell every sort of young professional is that if you don't want anyone to find out, just don't do it. I mean, it's not a matter of hiding it or taking it down. It's just not saying it.
Well, I guess, another piece of this, so we talked about social media, but there's a lot of other activity going out there. We have people who are marching at events and perhaps even interviews, or there's screenshots caught of them holding up signs. We have people pulling down lots of posters of the Israeli hostages. How do those type of events, I guess, first of all, it comes down to the employer ever finding out that they did it in the first place. But let's say the employer does find out about these things. Is it still the same kind of analysis? Those aren't necessarily words unless they were holding a poster. Have them participating in particular acts. So how do you feel that would be interpreted?
Well, I think there's not that much difference between the activity you describe and social media. Obviously, I mean, I don't think the average employer thinks anything of their employees participating in political events, as long as they're peaceful and they're lawful. So to the extent you have an employee who is, marching in support of the Palestinian people or marching against anti-Semitism, and it's a lawful and peaceful protest, I'm not sure an employer would think much of that. But when you start engaging in the activity of, becoming very personal, very graphic, violent, vulgar, whatever it is, you're tearing down posters, making, inappropriate comments that can be construed as, say, anti-Semitic. To me, that's as fair game as your social media postings. And to the extent it gets back to your employer, and again, you can be identified as someone associated with that practice. We all know how the media can just absolutely hammer things into the ground. So, again, I think the employer is going to have to look at the effect on its employees, its patients, its reputation, and, proceed as it could. Obviously, it wouldn't fall under, say, a social media policy, but again, look at your harassment policy, your EEO policy, and just general considerations of appropriate behavior. We saw this a lot, not so much a lot, but, with January 6th, people were caught on camera doing whatever it is they were doing, sometimes in the uniform of their employers. And, the big question was, well, can you do anything about that as an employer? And the answer is, well, absolutely you can. If you can tie somebody back to an employer, that employer has the right to say, we're not going to associate with this person anymore.
Right. I think that's really interesting. And, obviously, what I find is that people are getting in trouble for these things, but it's not slowing it down at all.
No,
and it is a lot of people who maybe aren't realizing that there's going to be a long-term impact on them. They're very caught up in the emotion in the moment. Well, let's talk a little bit about within the office. So within the office, we have employees interacting, and a lot of them have strong opinions. I mean, it could be about Republican versus Democrat. It could be COVID, about January 6th. So there's been lots of different things, especially in the past few years, that have created a lot of emotion.
Yeah.
And this whole situation, this war that's going on again is creating a lot of emotion. I would assume that the same type of rules apply within the office in terms of how you report your concerns and how you treat others. So maybe talk to that from an employment perspective.
Sure. Obviously behavior in the office is, to me, much more clear cut than, someone's social media or sort of behavior outside of the office. But an employer has the obligation to make sure that its workplace is free from harassment, discrimination, those types of things. And when you have someone, or a group of people in the office, being very belligerent, very aggressive, very vocal about their political beliefs, that can indicate to others that, maybe they're not going to be treated as fairly. And so, there's a couple caveats to that. People are allowed to express religious beliefs in the workplace, but they don't have the right to harass somebody, to demean somebody, anything like that. So, while you certainly can say, I support Israel, I support the Jewish people, that would likely be protected under law. but to have the kind of behavior we've been talking about in the workplace would not fall under those protections. So the other caveat is that under the National Labor Relations Act, which applies to both union and non-union workplaces, if employers are talking amongst themselves about workplace issues, which can often overlap with political issues, you do need to be a little careful about disciplining that. But to the extent that someone is being abusive, harassing, aggressive, even violent, absolutely, you have to. It's not even a matter of should you, it's that you must. And if that means removing the person from the workplace, then that's what your obligation is. And so the workplace is really, tied up in the policies that you have. But I would say that even if you don't have a really clear-cut policy, you can still rely on just that general obligation of an employer to protect all the employees in the workplace, not just a few.
Right. And to be clear, things like sending emails to your employees, which are harassment, anti-Semitic, posting memes, like posting signs, just sharing visuals, as well as making comments that are derogatory or anti-Semitic or anti-Muslim or whatever they may be, anti-anything. So it's verbal. It's something being shared via email. It's comments made with the intention of having somebody overhear. It is treating people differently. A manager suddenly treating one of the employees who might be of a particular political or religious belief differently than others. There's lots of ways we could see this happening. It doesn't have to be overt, like where you're calling.
And typically it's not.
Yeah.
I think people, at least have the sense to know that you don't just go around calling people slurs and names and, those kind of obvious insults. So what you do see is, like you said, the emails, you have a Slack text messaging thing in your office. You see things on that. It's rarely going to be directed at somebody, at least from a coworker's perspective, really going to be directed at somebody specifically. It's going to be more of a just creation of an environment. And that's as destructive, I think, as targeting someone specifically. But yeah, you do have, again, you're not going to necessarily see it in your hallways. You're going to see it, behind closed doors, in the lunchroom, those kinds of things, where it's a little less easy to detect. But once you start getting complaints, you really do have to move into action about that.
And I think, the other thing to be concerned about is, what if the person to whom you're supposed to complain is the one that either, supports the point of view or has made it clear they don't care. I mean, you could get yourself in a very difficult situation. Employers really need to, obviously, if you have a very strong view, if it's your practice and you have a very strong point of view, then nobody who doesn't share that point of view is probably going to feel comfortable working in practice. And I think we have to try and be neutral. We all are human and have opinions, but in the workplace, we can't really have those opinions. We need to put them aside, which can be super hard with these heightened emotions for people to do.
Oh, absolutely. And certainly if it's your business, there's always that temptation to say, I want to put my stamp on it. But like you said, you have to accept all people in your workplace, no matter any protected classification. And so the best practice is really to say, you must treat each other respectfully. That's not to say you can't have a debate about anything political. But it must be respectful. It must not be harassing. It must not be derogatory. And once it is, that's when we're going to put a stop to it. But the best practice really is just to be neutral. And, if you have those in management, especially, and God forbid, if you have your HR person who is engaging in that behavior, you really need to take a very close look at that, because that will cause you nothing but trouble. Especially if people don't feel like they could complain, or if that they complain, it's just going to increase the behavior. If you've got that situation, that needs to be addressed.
Right. Or else they'll go outside and they'll file like some kind of EEOC claim.
Well, that's the thing. You might not get the chance to fix it before it kind of blows up in your face.
Right.
And if the behavior is so prevalent that even like the top person in the office knows, you shouldn't wait for an actual complaint. You should do something about it. And be proactive, because like you said, they'll just go out. Uncomfortable employees will just go somewhere else and seek a remedy.
Right. Now, I guess one of the last things I want to talk about is when we're talking about healthcare practices, we're talking about patients, and patients come in for care. They trust their physician, their dentist, whatever. They assume that they're going to be treated well. The doctor has an oath, to take care of that patient, regardless of, their anything particular about them. There have been a couple of situations where people have posted things that made patients of particular religious backgrounds feel like, how can I go, to that particular doctor? There was a pediatric physician who posted something, and this is alleged, obviously, but something to the effect of, it's a good thing all those Israeli babies were killed. And this is a pediatrician. So how do any patients, particularly Jewish or Israeli ones, can they go to that doctor? Now, in the moment, the doctor may have said that and felt that way. I have no doubt that he or she would probably take care of all babies just fine. It's one of those moments. I find it
Yeah.
hard to believe they mistreat, but they put that message out there then about their professionalism, which could end up resulting in some kind of further investigation, a licensure issue. There was a dentist who literally talked about the idea that when and he was I believe I don't know if he was from if he was Palestinian or what country he was from, but he mentioned that when his Israeli patient comes in, he gives him extra anesthesia to shut him up or something to that effect.
Yeah.
Now that you're doing something that's not professionally necessary, that it's not the standard of care, again, opens you up to a licensure and investigation. Failure to prescribe, over prescribing, failure to diagnose, over diagnosing, or refusing to care for, canceling appointments. I mean, all of these kinds of professionalism things take the words and actions a little bit further to actual patient care.
Mhm.
It's going to take a little while before this all plays out, but I'm in the healthcare world and I'm hearing a lot about these kinds of incidents occurring, some of
Yeah.
which are media and some aren't. And so I think, it's really obviously in your grounds for termination, your policies, your standard of care, the fact that discrimination will not be tolerated, et cetera, are obviously standard provisions.
Mhm.
And I assume the same analysis, like let's say they're not posting something, but they suddenly are canceling all of a particular type of patient, or refusing, certain
Mhm.
types of care, or just doing something that's related to a particular class of patient. I assume, even though that could be really subtle to pick up on,
Mhm.
that same analysis would still apply.
Absolutely. I mean, again, like you said, if you can detect it, um, you have to address it. It's it's not necessarily an employment issue because, when you're talking about a patient, obviously that's in a different sphere. But at the same time, when you're talking about standard of care, you know, the, the simplest thing is, constantly canceling this type of appointment or appointment for, this category of patient, um, opens the practice up, not just the physician, but the practice up to charges of, discrimination, like you said, licensure issues. And it really, to the extent it is known, and we all know the media can't resist this kind of headline, that'll destroy your practice. I mean, I just can't see um, keeping any physician that has the poor judgment to either be as explicit or implicit as we're talking. Um, I just wouldn't want to be responsible for them because that's going to come back on the practice, especially if we know about it and we're not addressing it.
Right. Absolutely. And it's so hard to know. I think, one of the reasons I wanted to kind of talk about this today was because, what we're seeing is really something quite new and explosive. We saw hints
Mhm.
previously, but I think a lot of practices that don't have their own inside counsel, they don't necessarily have, a lawyer to call up right away. They're just not sure what to do. And some of these people that are engaging in this behavior may be wonderful doctors and dentists,
Mhm.
generally people that are very caught up in emotion and they're making bad decisions. But that aside, a practice is a business, and the
Mhm.
practice protect the business, and your obligation as the owner of the practice, the manager of the practice, shareholder, member, whatever the practice, is to protect the business. And I think, sometimes those decisions are not being made appropriately, where you're supporting the person as an individual, which is completely human and understandable.
Understandable, yeah.
But from a business perspective is not the correct approach.
Absolutely. And a lot of times when I get faced with that question of, well, he's our best, he's our biggest generator, the patients love him. You have to say, well, how valuable is he to you? If he's making these kinds of statements, he's maybe not the stellar performer that you think. But take a closer look rather than just say, oh, this is just emotion, this is just a temporary thing. Take a closer look at that. I mean, I think if you're a true professional, you know how to conduct yourself. And if someone's not doing that, it really does warrant, going beyond just the superficial and looking more closely at it. And if you need to, taking action. I mean, that's how you protect the practice.
Right, I agree. And short of termination, I mean, there are some other things that could be done. There can be suspensions. There can be requirements for somebody to seek counseling or be educated. I don't know that some of the behavior we've talked about today necessarily lends itself to that, but in the particular circumstances where somebody's just been, easily swayed and just needs to be maybe more educated or to understand how to better communicate or whatever it might be, hopeful there are other solutions. I mean, going around terminating everybody when there's so many people doing these things didn't seem like a great outcome, but it's hard sometimes to find a way that doesn't keep you at risk if you're the business.
Absolutely. And a lot of times, to the extent it can be chalked up to emotion, to, this is sort of the first, big thing I've, had to experience in my professional life, that person may be able to realize and go forward with no problem. And that's why I think you have to look at each case. I think a knee-jerk reaction to terminate or a knee-jerk reaction not to terminate is never going to be it's never going to be a one size fits all. So when you're faced with these kinds of things as an employer, you have to look at potential. Does this maybe we give them a last chance agreement, say, well, we're not going to tolerate this if it happens again, and in the meantime you're going to go do some whatever anger management, whatever it is. That may do the trick. But you also know your employees pretty well, and you know which ones are going to take the correction and those that won't. And again, it's never an easy decision to make. But you just have to do what's right for the practice and for your patients.
Now, we've been talking about healthcare, but certainly what we're talking about applies to all types of employers. Yeah. We've seen misbehavior by all types of employees out there.
Oh, absolutely.
So the same analysis really applies for all types of employers. And just one last thing I want to mention is that if you discover through this process that you don't have good contracts, that you don't have good policies, that you don't have a good HR person, that you had no idea about how to handle this situation and or got bad advice and didn't handle it, this is a good wake-up call as well to get yourself. This is not going to be the last time there are explosive events. I feel like there's more and more of them coming in this world today. And with social media the way it is, you can definitely expect it. So I think everybody should use this as a wake-up call to really go back to basics. What kind of social media rules do you have? What kind of policies? How can company devices be used? What kind of repercussions are there for things that impact a practice's reputation? How are you rebuilding relationships with your patients if these things do happen? So, I think I kind of wanted to leave people with the fact that if this has been a wake-up call that, you need to talk to your counsel, you need to
absolutely
kind of make sure that you're getting some basics in place.
Yeah, this is how we learn. When something goes badly, we can see going forward, we would do things differently. And so, again, like you said, this is a great opportunity, especially as we go into a presidential election year, which has all the hallmarks of being very emotional, very tense, that kind of thing. Maybe this is the time. If you don't have any policies like this or don't have very robust ones, let's tighten them up.
Right.
And, again, if you're renewing contracts or drafting new ones, let's make sure that they're elastic enough that protects you if you do need to exit somebody, that is a disaster for your business, for your patients, for your reputation. So those are all things, take up with your outside counsel. That's what we're here for. And going forward, it's never going to be a perfect system, but at least you have some tools to address it if you need to.
Great. I think that's great advice. All right. Any last thoughts on this topic?
Just if it's not one thing, it's going to be another. So, and they always
Right.
take different forms. I mean, I think pure political dispute is much different than what we're seeing here with Israel and Palestine. And, you just have to be prepared for all of it. It's unfortunate. It is a reality of our workplace that stuff doesn't stay outside. It all comes in. But, for the most part, I think when you instruct your employees that you must be respectful, a lot of times that goes a long way.
I absolutely agree. Well, thank you, Karen, for joining
You're
us.
welcome.
We hope you enjoyed this podcast. This has been the Retzel Health Law Hotspot. You can see more of our podcast at ralaw.com. I'm Erica Adler, and I'll see you next time. Thanks for joining us.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.